2, 1.
This Honorable Court of Appeals is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate all of you participating in oral argument via Zoom. We think it's probably the best way to conduct oral arguments at this time. All of you are experienced practitioners and know how this procedure operates. And today we'll be operating just as if we were all in the courtroom together. So the same rules and procedures will apply. Essentially, each side gets 15 minutes to make its oral argument. If you're sharing time in the oral argument, you need to explain what that time sharing is when you begin your oral argument. Also, if you're the appellant and you have reserved rebuttal time, you'll get 15 or you'll get up to 5 minutes rebuttal time if you've reserved that with the clerk beforehand. Before we start today, I want to introduce our panel. It's Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. And again, we thank you for participating. Ms. Angie, if you will call the case, please.
Emergency Medical Care Facilities, PC versus Bluecross Blueshield of Tennessee, Inc. et al.
And we'll hear from the appellant.
Good afternoon, Your Honor. May it please the court, Greg Reynolds for the appellant, EMCF. The Chancery Court erred in applying collateral estoppel in this case for several reasons. First, the intervening invalidation of the $50 cap significantly changes the predominance issue considered by the court in EMCF 1. Therefore, the first element of collateral estoppel, identical issues, is missing. Second, even if the invalidation of the $50 cap did not alter the formulation of the predominance issue, it clearly satisfies the exceptions to collateral estoppel recognized in this court's In re Bridgestone Firestone decisions. Specifically, a new determination is plainly warranted because by statute, any agency rule adopted in violation of the UAPA, quote, shall be void and of no effect and shall not be effective against any person or party, nor shall it be invoked by the agency for any purpose. I'm quoting from 10 Code Annotated 4-5-216. Applying collateral estoppel in this case would essentially give effect to a void rule that by law cannot be given effect or bind any person. Third, there was no final judgment, quote, concluding the rights of the parties on the merits, close quote. I'm quoting from the Bridgestone, from the Richardson case, the Supreme Court case, I'm sorry. And therefore, collateral estoppel cannot apply as a matter of law. Therefore, we request the court reverse the decision of the Chancery Court. First, the invalidation of the $50 cap makes the issues upon which class determination turns significantly different. In EMCF 1, the Court of Appeals, like the trial court, assumed that the $50 cap applied by contract and governed at least some of the class members' claims. The court reasoned that this meant individual determinations of whether services were emergency versus non-emergency would be necessary. Thus, the formulation of the issue in EMCF 1 was whether common issues predominated where the $50 cap governed some or all of the members' claims. Since EMCF 1, the only court with jurisdiction in the state to do so has held that the $50 cap violates the Tennessee Uniform Administrative Procedures Act and is therefore invalid, illegal, and void. Now, with the $50 cap being held invalid, the issue to be decided is very different. It is
that issue, Mr. Reynolds, is on appeal. Is that correct?
It is, Your Honor. It is.
Does that make any difference?
If, depending on the outcome of the appeal by TennCare of the invalidation of the $50 cap, it would make some difference to this appeal.
How so?
Well, Your Honor, if by chance we were wrong and the $50 cap was valid, then at least that basis for this appeal would be lacking. However, the other alternative basis for this appeal would still be present. That is that there is no final judgment upon which collateral estoppel can be based under Tennessee law.
Do we need to hold this matter in abeyance pending the outcome of the appeal in the other case? Is that the preferred way to do this, or are we able to proceed on?
Well, Your Honor, I submit that it would probably make good sense for this court to hear from the sister panel in the other case before deciding this case, because it'll make it easier. For instance, if the $50 cap is upheld as being invalid, then that makes this much easier to do. So, Your Honor, the issue now, assuming the invalidity of the $50 cap holds up on appeal, is whether common issues predominate where no $50 cap applies to any class member's claims. Therefore, it's an entirely different issue and collateral estoppel cannot apply. For similar reasons, and even if the elements of collateral estoppel were satisfied, the invalidation of the $50 cap is an intervening change in applicable legal context that justifies an exception to the collateral estoppel rule. And this is as announced in the Bridgestone-Firestone decisions. The Chancery Court, interestingly, didn't analyze the exceptions under the Firestone decisions at all. Under the Bridgestone-Firestone decisions, collateral estoppel should be rejected where its application, one, would contravene an overriding public policy, or two, where the issue is one of law and a new determination is warranted in order to take account of an intervening change in the applicable legal context. Redetermination is plainly warranted here because Tennessee has a strong public policy as reflected in 4-5-216 to prevent the enforcement of invalid agency rules directly or indirectly. Simply put, a new determination is warranted to avoid giving effect to an invalid rule that by law can't be given effect, and because the applicable legal context with the invalidity of the $50 cap has significantly changed. Third, Your Honor, the Chancery Court erred in applying collateral estoppel because there is no final judgment under Tennessee law. In Tennessee, quote, res judicata and collateral estoppel apply only if the prior judgment concludes the rights of the parties on the merits, close quote. This is from the Richardson versus Tennessee Board of Dentistry Supreme Court case. In addition, Your Honor, we have found at least 9 Tennessee Court of Appeals decisions reciting this requirement of Tennessee law for collateral estoppel to exist, including most recently Judge Golden's 2017 opinion in Jones versus BAC Home Loans Servicing Limited Partnership, an opinion which the Chief Judge Stafford joined in. Judge Golden wrote there, again, comma, collateral estoppel as well as res judicata, quote, apply only if the prior judgment concludes the rights of the parties on the merits, close quote, quoting Richardson. Orders granting or denying class cert are inherently interlocutory and are not final. In fact, the Tennessee Supreme Court has held that a class determination cannot be made final, even if it allows the plaintiff to proceed on the individual action. That's the Bayberry case. The Court of Appeals decision did not decide the merits of any claim. It left the plaintiffs to pursue their individual claims, and therefore under Tennessee law could not be a final judgment in any sense. Furthermore, this case ended in a voluntary non-suit over the objection of Bluecross Blueshield, I might add, and the order specifies that dismissal is expressly without prejudice. Non-suit does not conclude the rights of any parties on the merits and cannot result in issue or claim preclusion under Tennessee law. I'm citing the Bentz case and also the Frank Rudy Ayers case, Your Honor. Bluecross argues that Bentz is an old case and isn't relevant anymore, but it's never been overturned. By contrast, no Tennessee court has ever before adopted Section 13 of the Restatement of Judgments, which rejects Tennessee's final judgment requirement in favor of a mushy, quote, sufficiently firm, close quote, standard for collateral estoppel. And Section 13 also ignores the established Tennessee law regarding non-suits. Finally, if the court were to determine that Section 13 of the restatement ought to be adopted, it should do so only prospectively. EMCF relied to its detriment on the previous Tennessee law requiring a final judgment concluding the rights of the parties on the merits before collateral estoppel could apply. And this would be a significant change in the law. So for all these reasons, we submit that reversal is proper and that this court should remand to the Chancery Court for a determination of class certification for all parties. Thank you.
All right, thank you very much. We will hear from the appellees.
May it please the court, Gary Shockley of the Davidson County Bar on behalf of the appellees, Bluecross Blueshield of Tennessee and its subsidiary Volunteer State Health Plan.
Are you making a full argument, Mr. Shaw?
Mr. Mayor has asked for 1 minute, Your Honor.
Okay, I just need to know for keeping up purposes here.
Certainly.
Go ahead.
As of today, the case before the court is 7 years and 1 month old. Yet after those 85 months, the parties, or at least one of the parties, is still seeking to litigate class certification, an issue that Rule 23 requires to be resolved as soon as practicable after filing. And of course, an issue that was subject to a definitive and final ruling by the Court of Appeals on November 28th of 2018, pursuant to an appeal as of right that was not subject to any further review. Under Tennessee law, going back at least 1859, every party is entitled to a full and fair opportunity to litigate factual and legal issues. But having had that full and fair opportunity, no party is entitled to relitigate those issues. Here, it is undisputed that EMCF had that full and fair opportunity, was subject to a final judgment in the court's own words in November of 2018, and cannot relitigate its motion for class certification yet again 3 years later. In their briefs, the appellants have put forth 3 arguments. The first, that this court's decision of November 29th of 2018 was somehow not a final judgment. The second, that a trial court ruling in a case that did not involve the same parties has somehow worked a change in the governing law. And third, in an argument featured on appeal for the first time that applying issue preclusion here would be a retroactive new rule. The record demonstrates otherwise on all 3 points. And the interests of finality, fairness, consistency, and judicial economy that underlie and have always underlain the law of issue preclusion supports the business court's ruling below. So to take these in what seems to me a logical order with respect to the question of, was the Court of Appeals decision a final judgment? Well, we know it was a final opinion of the court and it's no longer subject to appeal. It was reviewable within 10 days under Rule 39 on a petition for rehearing, which the appellants, the EMCF there, originally said they would file but failed to do so. It was subject to discretionary review by the Tennessee Supreme Court within 60 days based on a Rule 11 application. EMCF chose not to do that. The mandate of the court issued on February 14th of 2019, and it was remanded back to the Madison County Circuit Court for proceedings on EMCF's individual claims, which it still has and has always had, and will have when this case is remanded back to Davidson County. It wasn't until 7 months later, with a motion for summary judgment pending, that EMCF took a contested non-suit. The prior decision of this court adjudicated all the issues before the court on the appeal as of right under 27-1-125 and is no longer subject to review in any court.
What's the effect of the non-suit?
The effect of the non-suit is to preserve their cause of action, Your Honor, to preserve the individual cause of action as it existed in September of 2019 when they took that non-suit. That is their breach of contract claim and their individual declaratory judgment claim. That they have preserved that claim. It is still available to them when and if they are ever interested in pursuing it. That's not been the case so far.
So what's the merits determination here then?
The determination here, the determination on the merits in EMCF 1 was whether the case was certifiable as a class action under Rule 23.023 of the Tennessee Rules of Civil Procedure. That was the merits before the court under an appeal as of right by statute that the court conclusively resolved, and it's precisely that issue that they're seeking to relitigate now in Davidson County almost 3 years later.
But isn't it based upon the facts that existed at that time?
It is, Your Honor, and those are the facts that exist today as well. The claims they've asserted here are the same claims. The parties, Bluecross, Blueshield, and Volunteer State Health Plan are the same parties, and as we'll address, the issues remain the same under Rule 23 and this court's prior ruling.
$50 determination a different issue now because of the action of the Davidson County Trial Court?
It is not, Your Honor, and we'll turn to that. The reason it is not is this court's decision expressly held in EMCF 1 that the case was not certifiable as a class action under Rule 23 because it lacked predominance of common issues, and importantly, that was the case regardless of whether the change was a state law or not. The court expressly declined to resolve that issue and said it was unnecessary. That in addition to the question of whether it was a state law, the court held, not assumed, but held, based on the plain language of the agreement and the positions of the parties, that there was an amendment of the contract to put a new rate in place as a matter of contract in June of 2012. The court held that there were individual issues because of the different TennCare Select amendment that applied to a portion of the class. And the court held, following Crouch versus Bridge Terminal Transport, that there was individualized issues based on the affirmative defenses of waiver and estoppel. The court relied on all three of those and found it unnecessary to resolve the question of whether the $50 cap was valid as a state law or not. That's the issue that the chancellor below addressed in EMCF 2, and she correctly realized in this case that her own decision did not work a change in the governing law. In fact, that makes sense when we think about it. It would be difficult for the Chancery Court to work a change in the governing law and effectively overrule this court's decision in EMCF 1. That's simply not the way the appellate court system works. We also believe that it was, in fact, a final decision by this court, because under Rule 38, the decisions of the Court of Appeals are a judgment of the Court of Appeals. Rule 38 uses the word judgment in 5 different places in one paragraph. When this court issued its mandate on February 14th of 2019, it referred to that as its judgment. And it is a judgment in that it resolved 100% of the issues before the court and was not subject to any further review in any court, certainly not in an inferior court in a different lawsuit. We would cite Richardson versus Board of Dentistry to that effect, where the court gave a preclusive effect to its ruling on a set of constitutional issues without reaching the underlying merits of the enforcement action, and that unappealed trial court ruling was subject to preclusive effect. We'd simply submit, if an unappealed trial court ruling is entitled to preclusive effect, then certainly a decision of the Tennessee Court of Appeals, final and no longer subject to appeal, is entitled to no less effect. We'll also point to the State versus Mendenhall decision from last year from the Court of Criminal Appeals, in which the court held that a ruling on a motion to exclude evidence in a criminal case in Davidson County was entitled to preclusive effect in a case against the same defendant in Wilson County. Tennessee courts routinely cite the restatement of judgment, which is what the trial court relied on below. Now, the case that was relied on most heavily below by the appellants here was the Illinois Central Railroad versus Bentz case, a 1902 decision from the Tennessee Supreme Court. Old cases, just like old lawyers, are still good as long as they keep current. Unfortunately, the Bentz case has not kept current with developments in the Tennessee law in the intervening 120 years. In the first place, it's a decision that addresses res judicata or claim preclusion, not collateral estoppel or issue preclusion, which is the question here. It has, in fact, been overruled on its holding on damages, on salatium damages, as it's called, which was disallowed, and which the court has more recently allowed in wrongful death cases. It has not been cited at least since 1937 on the issue of preclusion, claim preclusion in that case, over 80 years. It also applied differing federal and state rules on the fellow servant doctrine. Again, an anachronistic doctrine that doesn't apply in any event. Bentz does not represent the law in Tennessee on damages or issue preclusion in the 21st century, and that's nowhere more readily demonstrated than in Bowen X. Rel. Doe versus Arnold, the Tennessee Supreme Court's 2016 decision that, again, applying the restatement second of judgments, found that non-mutual offensive collateral estoppel was available in the state. The cases cited by EMCF in their brief all predate the enactment of the current version of Tennessee Code Annotated 27-1-125 as part of the Civil Justice Reform Act of 2011, which added an appeal as of right, not a discretionary appeal as was available before in Tennessee, not a discretionary appeal as available under the federal rules, but an appeal as of right. EMCF took advantage of that appeal as of right. They lost fair and square, and that decision was final and no longer subject to appeal. They've cited a number of cases, such as Bayberry Associates versus Jones, that they've cited here today. That's a case that holds under Rule 54, or Rule 54 judgment is not available in a class action case. That case predates the 2011 Civil Justice Reform Act. This was not an interlocutory appeal. This was an appeal as of right, resulting in a final decision. They cite the Rudy Ayers case. Well, the Rudy Ayers case involved an oral ruling by the chancellor previously in that case. We didn't have an oral ruling here. We had a hearing in front of the Madison County Circuit Court. We had a reasoned decision. We had an appeal as of right. We had a reasoned decision that's now final. And none of those cases they cite address the issue presented to the court today. As we mentioned in addressing Judge Stafford's question, the second argument they make is the subsequent change in governing law exception. That simply does not apply here. The governing law has not changed. The governing law on class actions is Rule 23 of the Tennessee Rules of Civil Procedure, which is the same today as it was on November 29th of 2018. The UAPA issue was not raised at any point by EMCF in that case. And if they thought that the court erred, their remedy was to seek rehearing or review in the Tennessee Supreme Court, not remand, non-suit, and refiling in a different court. Chancellor Martin correctly recognized here that her own decision in EMCF 2 was not a change in the governing law. And that makes sense. A trial court judge can't change the law as explained by the Court of Appeals. As we noted, there were 3 independent bases for denial of class certification in EMCF 1. One was that because of an amendment to the provider manual, there was a separate contractual basis entirely independent of state law. The second was that the TennCare Select contract made individual issues predominate, and waiver or estoppel. None of those facts have changed. None of the applicable law has changed. The State versus Crawford case is a good example of when the law does change. There, the General Assembly, after the first action, amended the legitimation statutes, granted standing, and expressly exempted new cases from preclusion doctrines. None of that's the case here. Finally, Your Honor, on the retroactivity issue, we don't have an issue of retroactivity here. We're applying a 2018 decision to a 2020 case. It's not a new rule. It applies settled principles of Tennessee law in the interest of finality and consistency. And Callaway versus Shucker is a case that demonstrates what a retroactive rule looks like. That's simply not the case here. So for all of those reasons, Your Honor, we suggest that this court's prior decision continues to govern on the issues that it resolved definitively, and that consistent with the authority regularly relied on by the Tennessee courts and the underlying policies of finality, fairness, consistency, and judicial economy, the ruling below should be affirmed. And I'll let Mr. Meyer address his issues.
All right, thank you. Mr. Meyer.
May it please the court. My name is Jason Mayer, and I represent AmeriGroup Tennessee. I want to echo and join in a point that Mr. Shockley raised during his argument. EMCF's appeal argues, among other things, that a separate Chancery Court ruling that TennCare's so-called $50 cap rule is invalid, that ruling would have altered the decision in EMCF 1. Such a finding would, in effect, overturn the court's prior decision in EMCF 1, and the court should not do so. Specifically, EMCF 1 already considered whether the validity of that TennCare rule would have affected EMCF's request for class certification and found that it would not. Those rulings were in the Westlaw publication on pages 7 and 10 and footnote 5. There is no need to revisit or overturn that ruling now.
Thank you. All right, we will hear a rebuttal from the appellant, Mr. Reynolds. You have 3 minutes, I believe.
Thank you, Your Honor. I'll be brief. First, I'd like to answer a question that you asked. That isn't the issue different now than it was back when Judge Golden authored EMCF 1? And you received an answer that was whether or not the $50 cap was state law didn't affect the opinion, but that's deceptive. It did not, the court did not hold that regardless of whether the $50 cap was illegal and unenforceable under Tennessee law, under Tennessee statutory law, that class certification was improper. In fact, the court assumed that it was allowed to be enforced through contract. We know now, as a result of the invalidity of the $50 cap, that it can't be as a matter of statutory law. Second, Richardson, it's not accurate that Richardson allowed collateral estoppel to apply to a separate non-merits challenge. That was a separate lawsuit that determined the constitutional challenge, and that lawsuit was not appealed. So Richardson does not support them. Third, Bentz holds that a non-suit cannot support issue or claim preclusion under Tennessee law, not federal law. Fourth, the exception that they've the exception, the changes in applicable legal context, it's not changes in Rule 23 that matter, as the court observed in EMCF 1. It's changes in the legal context. That is, does the $50 cap apply pursuant to contract or otherwise? And Judge Golden wrote on page 9, indeed, if there was no incorporated provision of state law providing for a $50 cap, then application of such a non-existent payment term would be equally invalid as to all providers who had TennCare claims within this subset of the class. It would have mattered. Finally, Bluecross cites no case law holding that an invalid rule is effective for any purpose under Tennessee law, whether by contract or otherwise. Cites no law holding that collateral estoppel applies where there's no final judgment that concludes the rights of the parties on the merits. Cites no law adopting the restatement section 13 sufficiently firm standard in place of the Tennessee law, and cites no law that collateral estoppel can apply when an action is non-suited. Thank you.
Thank you, folks. We appreciate your argument. We will take this matter under advisement, attempt to get you an opinion as soon as possible, hopefully resolving this issue. We again appreciate you participating with us via Zoom oral argument. Ms. Angie, if you will recess court till the call of the docket in the morning, please.
Thank you, Your Honors.
This honorable court stands adjourned.
Thank you, folks. You can withdraw from the meeting now.
Thank you.
Thank you.